and I want to remind everybody that the panel, neither the panel nor the council assumes any liability for comments we say. So, in other words, keep it positive and focused on the merits of the issue. Also want to advise that the panel has had the opportunity of a site visit, as well as reading the submissions on the original plans, as well as the submissions that have come in relation to the amended plans as well. So this is now the opportunity. I'll ask the other members of the panel to introduce themselves in a moment, but otherwise this will be the opportunity to hear from submitters who have registered, and also from the applicant in relation to the amended plans, and then the panel will deliberate on a determination, and that determination will be issued before the end of, well, let me think, actually, I don't know the timing. I might just refer to council staff for a moment there. The timing of the release of the findings or the determination today. Does someone want to say that?
Have a guess.
Tom, can you help us out, or is anyone just procedurally, when will the decision be issued?
So after this, we will produce draft minutes for your review, Rob.
Yep.
So they should come back to you this afternoon. It's just the one.
Okay. Okay, so we should be able to finalise this before the end of the day. In other words, the minutes will go up later this afternoon, just in terms of timing. So having said that, I'll just ask both Cara and Greg to introduce themselves to everyone online. Thank you.
You want me to go first?
Yeah.
Hi everyone, I'm Cara Creason and I'm a consultant town planner with around 30 years experience.
My name's Greg Woodhams. I'm a town planner, worked for local government, private sector and state government for about 35 years.
And my name's Meredith Trevelyan-Jones. My qualifications are in architecture and urban estate management, and I'm the community representative on the panel today.
And apologies, Meredith, to leave you off there. You were off my screen, so I didn't, but thank you as well. So I note in the items to cover, first, the minutes of the previous meeting were confirmed following the meeting. That was the meeting of 4th December. Are there any declaration of interests by any panel members?
No,
no conflict of interest from me.
Not from either. Okay, well, we've got one item on the business paper, being the consideration of DA number 85 of 2024, address being 1 Warrong Street, McMahon's Point. And we've got 4 registered speakers. I'd call first to address the panel, David Uther from 3 Warrong.
Thank you, Chair. Members of the panel, good morning. Thank you for allowing me the opportunity to address you. I'll keep to my 3-minute limit. As you have mentioned, my name is David Uther, and together with my wife of 60 years, we live at 3 Warrong Street, McMahon's Point, and have for over 30 years in our heritage home. We live next door to the applicant of DA 8524. They adjoin our western side of our property. We object strongly and are horrified at the increase in bulk, overlooking, excavation and impact on our heritage home, which we love and have restored and are very proud of in our community and in our heritage area. We were encouraged by councils and the previous panel in rejecting the original proposal, the second proposal, and we want refusal of this proposal. Let me point out the following, if I may, please. The current DA has defied the panel's requirement for an additional 1 metre setback on a substantial part of our boundary, approximately half. There is no geotechnical report as to our property. We have never been requested for permission or authority for any such report. We have never met the applicant or any of his contractors or employees. There is excessive height on the southeast corner of this proposed DA and excessive height overall. The southern verandas need setting back to the size of what there is now and properly screened by fixed screens to the east that overlook our property. What is proposed is unbelievably intrusive to our living space. We will have zero privacy. It is so horrific. My wife is wishing to leave the home. The proposed building on the southern side is excessively forward and is intrusive to our privacy. It is in excess of the building standards. It defies the previous panel's request to set it back. The privacy to our heritage home from all windows, all openings, including verandas, all need privacy screens in addition to vegetation on the total length of the eastern side of their building with a 2-metre setback. The northeast building will take our light, sun and amenity and privacy into our kitchen. The building design is not compatible with the heritage character of the Warrung Street Heritage Precinct. We accept what was there when we moved in 30 years ago, but this proposal is shocking in terms of loss of the privacy, amenity and sheer bulk, and the digging underground on our boundary or within 2 metres of our fragile heritage home is just terrible. There are now 4 windows in the current building, and this will triple, quadruple, plus a huge increase in intrusive verandas. We want our privacy. Is it too much to ask? We have had it for 30 years, and now it is being washed away from us. This is our home, our heritage home being destroyed. We very strongly object and ask the panel to reject the DA 8524. Thank you very much.
Thank you, Mr. Youther. Are there any questions from members of the panel to Mr. Youther?
Not from me.
Perhaps I could ask, Mr. Youther, that you mentioned that the latest proposal still defies the panel's position about an additional 1 metre setback. Can you just clarify what you mean by that? As I understand it, it has
the original panel asked for a 2 metre setback along all boundaries, sorry, to the east and the western boundaries.
Mm-hmm.
On the eastern side, their eastern side, our western side, the setback has been 2 metres, about half the length, and only 1 metre for the length that is on the southern side.
That's where the driveway is.
Yes, where the driveway comes in.
Yeah.
Our house is built directly on the sandstone, the rock face. It has no footings. It has no structure, as is a modern home. It was built in 1881, and the standards then, whatever applied, aren't the same as now. So we are very concerned about our structural integrity and privacy, of course.
Thank you.
Thanks. There being no further questions, I'd like now to call on Mr. Moody, who is who's also representing the Youthers, to provide evidence to the panel.
Chair and panel members, may I just thank the council officers and the panel for giving us an opportunity to comment on the amended plans. Your courtesy is greatly appreciated. This matter has had a very long history. And as Mr. Uther has rightly said, the original proposal, which is not that much different, quite frankly, particularly as it relates to my client's heritage item, was recommended for refusal by another assessment officer of council. It went to the previous planning panel, and that was roundly and unanimously rejected. The process through the court obtained an agreement. The court was bound to approve. But that's a brief history. I want to concentrate now on the heritage impacts, or I'll retract that. I'm not a heritage consultant, but I want to concentrate on the impacts on my client's heritage item. It is my strong position that the application should be refused, but I want to raise issues of concern of particular elements. The depth of the balconies. There are modest balconies in the southeastern corner adjacent to my client's heritage item. One only needs to have a look at that, of what currently exists. And Mr. Uther honestly acknowledges that they have to accept what's there. What is now before you are expansive balconies ranging from 18 to 20 square metres, probably 100% and more compared to the existing balconies. And the top balcony is 91 square metres, in circumstances where the council's planning controls speak of 8 square metres as the minimum. So what you have before you for an existing use right, and you'd be aware of the court planning principles, that there's no absolute entitlement to expand on what's there. You have balconies on all 3 levels in the southeastern corner directly adjacent to my client's property. The council assessment officer has asked for one of the levels, level 3 as I understand, to be recessed back in line with what is the southwestern proposed balconies. If you're of a mind to approve the application, there's no reason why levels 1 and 2 balconies should not be handled in exactly the same manner. This is a serious intrusion, visual impact and overlooking impact. And just on overlooking impact, it isn't solved by privacy screens. What that does is just add more bulk adjacent in the curtilage of this heritage item. So if you're of a mind to approve, hopefully not, the level 1 proposal to move that top level balcony back should be echoed for levels 1 and 2. We ask for that to reduce impacts. About the excavation under the heritage item, no engineer from the applicant ever came to my clients. I don't need to tell the panel members, based on your qualifications and experience, that heritage items do not have the same foundations and footings as normal buildings. We earnestly requested them to come on site. There was no such. So the geotechnical, I'm not quibbling with the expertise of the applicant's geotechnical consultant, but he or she cannot come to an informed opinion about potential impacts by this very significant excavation where there's no basement now, without knowledge of access to my client's property. My clients have honestly agreed and rightly agreed to provide such access. In my submission on the 19th of February, if you again agree, if you're of the opinion that it should be approved, there should be a requirement requiring the applicant's geotechnical engineer to come on my client's property. I consider that's an essential. Regarding overlooking, there are 4 windows facing my client's heritage item. 4 on the eastern elevation. As Mr. Uther quite correctly said, this is multiplied. If I think the level of overlooking is most severe, not only from the windows, but also the large, very large extended balconies. If you're of a mind to approve, and hopefully you aren't, every window on that side elevation should be provided with privacy screens. And the solution is not landscaping. As you're keenly aware, Super Studio says proposed landscaping should be given little weight in the court planning principle. My client should not have to suffer the serious intrusion. I'm amazed that when you have a heritage item next to you, my general understanding is that you require a more sensitive development than normally the case. This has actually flipped that principle. They've put the biggest balconies, the largest number of windows on the elevation facing my client's heritage item. The additional 1 metre setback is, as Mr. Uther said, and it's attached to my email of the 19th of February. Part of that has not achieved the 1 metre additional setback you required. Now, the applicant might say, oh, there was much discussions about the access driveway and the design and its location during the court. I've received advice just this morning from an eminent traffic consultant who says 6 metres from the tangent point, you can have a driveway. This distance from the proposed driveway to that tangent point is well in excess of 6 metres. So you can clearly provide an increased setback based on the Australian standards. And I urge the panel members, well, with your own expertise, you'd know that. There's no reason not to require the additional setback. This is a very difficult presentation for me, because if it was of my decision, and it's obviously not, I would refuse the application. But I ask you, if you're of a mind, to refer you to my submission of the 19th of February, which seek at best some amelioration of the potential impacts. I consider that this is one of the most insensitive interfaces with a heritage item in my 40 years experience that I have witnessed. Thank you very much, panel members.
Thanks, Mr. Moody. Do panel members have questions for Mr. Moody?
No, but I'd just like to thank Mr. Moody. His submission did provide some conditions, draft conditions for us to consider. That was very helpful. Thank you very much.
Thank you. That's on the basis.
Of course.
Thank you. I appreciate that. Thank you, Mr. Williams.
And Mr. Moody, just one from me as well. So your statement is that at no stage has the applicant sought, they've been invited to go on to your client's property for the purpose of geotechnical investigations, but has refused or just not responded?
Well, there's been no acceptance, so to speak. Can I say I raised this at the previous panel member meeting, and I don't know whether all the current members were at that previous meeting. And I put forward, I used to be a lawyer, but I put forward the proposition that I don't think this matter can be addressed by a condition of consent. I think it's an essential matter for consideration, because this basement excavation is not only significantly larger than the original proposal, but just imagine the potential. I can't grapple with the fact that a geotechnical hydrological report has been prepared without the benefit of inspecting my client's subsurface conditions, because my experience is they're not to the current standards in any way, shape or form based on normal heritage items.
And yeah, because I do recall it, and it is the same panel that you presented to last time, Mr. Moody. And so my understanding was that the amendments have not been prepared on the basis of any geotechnical investigation that you're aware of that's involved your client's property. Okay.
And as my recollection is, I mentioned that last fact again previously. And so the report is based on what I'll call standard, and I'm not doubting the credibility of the firm. I must stress that. What I'm saying is that how can one, and it may apply to 95, 98% of circumstances, but not when you have a heritage item next door, with respect.
Thank you. Anything further from the panel? Oh, yeah, Cara.
Yes, Rob. I just look. I will go back and check the survey plan again, but you may just be able to assist more quickly than I do that process. I'm just keen to be reminded of the walls that are along the boundary, the shared boundary, and in particular, obviously, the quite elevated wall at the front. Towards the front of the side boundary. Are they, I will look at the survey plan, but are they on the boundary or on your client's property or within the subject site? Just if you're able to answer that quickly, but I will check myself as well.
I can't answer that. I'm sorry, but I think you're right. I think it's either very close or on, correct. But it's also what's underneath in terms of the foundations and footings.
I mean, I know what you're talking about isn't just about the walls, it's about the house. So I'm not trying to infer that.
No, I understand.
It's just a separate question. I mean, perhaps David Uther might be able to answer that, Chair.
Can I say there's a very, to the credit of the applicant, there's a very detailed survey plan which was lodged in the original application some years ago. So, panel member, you may wish to go to that.
Yeah, that's right. I checked our package and it's not in there, but that's why I have to go back to the system and have a look for it.
Yeah, it's on the. They've got a very good system. Obviously, the DA tracker has it. Thank you.
Cara, did you have a question then? Sorry for, I noticed Mr. Youth is still on.
Oh, if Mr. Youth just had that information at hand, from his understanding, that would be good to know.
Look, I don't. I'm sorry.
Okay, that's okay.
But I can make an assumption that the boundary, is a shared boundary. It's on the line between the two homes. That's what I assume.
Sorry, I know I should probably wait my turn, but that large Besser block concrete wall is on our client's boundary.
Oh, fully within the subject site?
Yes, it is.
Okay.
Yeah, I just thought, because I know the answer, I thought I'd answer.
Yeah, okay, thank you.
No worries. I'll wait my turn now.
Panel members, I must go on an urgent second meeting. My apologies, but I must leave the meeting now. Thank you for considering it. My submission. Thank you.
Thanks very much, Mr. Mooney.
Thank you.
Terrific. Now we go on to the apologies, I've just momentarily lost the minutes, but we now go on to the applicant, and I think first we have Mr. Vesio.
Yes, good morning, Mr. Chairman. Thank you, and thank you, panel members. I wasn't intending to regurgitate the submission that I'd made previously to the panel, because I thought that most of the issues that were raised by the neighbours had already been carefully considered by the panel at the last meeting. Unfortunately, there are some factual errors and statements made by Mr. Moody, which I will take up separately. However, one which is, I noticed got the attention of the chair, was there certainly has not been any request for our geotechnical engineer to attend the neighbouring property. That has certainly not occurred, and that's just a false statement that unfortunately leads to some presumption that we are not, conciliatory in any way. We're certainly far from that, and my client is certainly far from that. The conversation, obviously we knew the sensitivity of and the concerns of the neighbours from the submissions, from the presentation to the panel last, and the specific conversations that were had with the geotech engineers were that there is nothing unique about this situation. In fact, they are comfortable because the adjoining building is set back in the order of 4 metres to 5 metres in some places from the excavation, that this is really stock standard stuff. Nothing unique or anything that raises any concern other than what they would ordinarily deal with every day of the week. And that measures will be implemented at the construction certificate and design stages to ensure that the excavation is monitored. There will be dilapidation reports prepared. Like I've said before, it's in our client's interest to make sure that there's no damage to next door. It's not the council that's going to wear it, it's the developer that's going to wear it. So they're certainly cautious and acknowledging of that. I wanted to go to, I'm hoping that my submission, my written submission that I put forward to the panel has already gone to the panel. I don't want to revisit that. I think that my arguments have been put forward. I thought it was a carefully thought out and responsive compromise that the panel came up with as part of their resolution. It maintained the architectural integrity of the built form and the aesthetics, whilst balancing the amenity for both properties. In terms of the conditions, like I've said in my written submission, we have no objection to 41A. we do object to 41B, and we strongly oppose 42. And the reasons for that will be elaborated further by Mr. Squalacci in terms of the design integrity impacts. I mean, as the panel knows, this is a dense urban setting. As density increases, and it's bound to increase with the moves by the government to increase densities, there's going to be necessity for compromise and balancing of amenity. There's going to be some compromises to privacy, overshadowing view impacts that will follow as a consequence of creating a more denser city. I think that the residents need to accept from both parties that there's going to be some compromised amenity. We're in an urban area. We're not in a rural setting where we can maintain privacy. There's going to be some impacts that occur, and they need to be balanced against other amenity interests, such as views. And in a situation like this, where you're on a waterfront and you have iconic views of the Harbour Bridge and the Opera House, that I think that that is a reasonable entitlement for all of the properties along this side of Woorong Street. I will leave it in the, and in terms of privacy, as the panel saw, impacts already arise. They're already there. I don't think they've been aggravated. I actually think that they're being improved. As I said in my submission, we're over the requirement of the ADG. So I just rely on my submission in terms of my argument in support of the proposal, and I'll leave it in the capable hands of the panel to weigh up our submission. So thank you.
Yeah, thanks, Mr. Vessia. Any questions from the panelists?
I have a question, but perhaps it's probably to the architect. It's about the western side, not the eastern side.
Well, but perhaps in which case, maybe if Mr. Vessia, you're happy to stay on the line, and we'll hear from your architect, and then collectively at the end we can ask whatever questions. Terrific. Okay, in which case I'll ask Mr. Squillis to take us through his responses to what's been said so far. Thank you.
Thank you, and thank the panel for allowing me this time to speak this morning. I was intending to do it in a minute, but it sounds like I'm going to have to address the scare campaign on the excavation. So I might just start with that. If you look at the floor plans of the basement, the entire boundary is set back over 2 metres, and they are a piling system called contiguous piles. And the reason they look so dense and different to the rest of the excavation is because the rest of the excavation are soldier piles. Soldier piles are typically 1.5 metre spacing, and they're good enough to support the soil and weak rock, weathered rock. Contiguous piles are when you have a situation like this where you want zero tolerance. Now, to put this in context, we're currently working on a project in Double Bay on far worse foundation conditions than this, where this piling system is on the boundary and the neighbouring properties are on the boundary, significantly heavier than this building. This contiguous piling system is over 6 metres away from the heritage foundations. And excuse me if you already know this, but I just want to explain, they overlap, they go into class 3 or 2 or very strong bedrock first, then there's a structural capping beam, and only then does excavation occur. So this doesn't even come close to the type of risky situations that I've worked on. Douglas Partners are, if not the most, they're in the top 2 geotechnical engineers in the country. There's no way they would stand by and issue any letter of any type if they thought there was any amount of risk. So I just think that just addresses that matter. And in terms of moving the driveway, it is actually for heritage reasons that it's located in that spot. in the previous application, that was the part of the rock face which was cut for the trams. That was the part of the rock face that was fractured, had concrete sewers going down it, and some patchy brickwork. And we carefully site measured, laser measured, and 3D modelled that exact rock face to universally agree that that was the perfect entry spot for it, and it hasn't changed. So moving it 6 metres away from a house from the urban environment will have no benefit to the curtilage of the house, but will only destroy a very good part of that rock face and preserve a fractured, previously modified part of the rock face that has concrete sewers and patchy brickwork on it. And that's why that's there. And all of these issues have been considered on over 2 applications and for months. Now, if I can just spend my brief time on my passion. Firstly, I agree with Mr. Vecchio that on privacy, the panel didn't, I could only assume the panel didn't require additional screening because we now comply to the ADG separation. But look, the eastern window, and even to some extent, if we mask the planter box, can be dealt with. I think the eastern window is fine. The planter box on the eastern boundary is unreasonable, given that we're some 7.5 metres away from the boundary and well in compliance with the DCP. However, my main issue here is the condition C42. After a year of design excellence panels, collaborative refinement, which actually also includes the panel's recommendations, which, although there was some changes, I felt maintained the design excellence, a design excellence which was endorsed by the design excellence panel. How can such an ill-conceived sentence be even considered that would have such a ripple effect on the harbour foreshore and the architecture of this building, everlasting, if you like, for no gain? Especially if the planter box goes there. There's just no gain at all. There's no overshadowing issues. There's no privacy issues. The only issue is that we'll be destroying what is an excellent piece of architecture, and it will be there on the foreshore forever. It'll look like a wedding cake. It'll provide no cover to the balcony of apartment 202, which is south facing. And again, for no improved design. And I'm struggling to even understand how I could sign a design verification certificate. The panel, I have to consider more than Mr. Moody's requests, which I think are unfounded. I have to consider the foreshore, the harbour, the building, the built environment, the legacy that we're leaving the built environment. This is a conservation area of eclectically mixed buildings, but what we all share in common is that they're all a fine example of, or most of them anyway, a fine example of their era. So whether it was built at Blues Point Tower era or in the 1880s, most of these buildings are a fine example of their era rather than a consistent streetscape of bungalows. So we're informed by designing a fine example of a building of our era. And to use Mr. Vecchio's quote, we don't want to be a camel, which is a horse designed by a committee. This has been well considered, and the panel suggestion of the December meeting were well considered, and I support those. But I don't support wedding cake design for no gain whatsoever. Thank you very much.
Thanks, Mr. Squillis, very much. Any questions to either of the applicant representatives from the panels?
Got just a couple of questions from me. Vince, just turning to the western side, I just want to be clear about the positioning of the building. The existing residential flat building on the western side has an alignment that I think has been looked at through the court case and through several versions, but I understand that the latest revision E doesn't align with the existing wall of that building. Can you confirm that it does or doesn't? I just want to be sure about that.
No, it doesn't, but neither did all the previous versions. We haven't altered that with this design. That western wall location has been there since this application was lodged, and I just want to add it's well within the setback, and it's been positioned in such a way, because what we've done is we've moved the mass away from the non-compliant corner. So the building in the south and east corner are significantly more forward than our proposal, and that's the part of the site that's non-compliant. So we've just pushed the mass into that corner in collaboration with council, and that corner has been designed so that the building mass can be there and maintain the diagonal views across from Blues Point Road.
That was the thing. That was what's been in my mind, is those diagonal views, and that I've seen some photos from, I think it was Unit 42, where the position of the existing building allows the view of the southern pylon of the Harbour Bridge, whereas the nudist scheme is about, I think, about a metre closer towards Blues Point Road, and therefore might truncate that view of the southern pylon.
We've actually addressed that in our submission to council last November. So we've moved the part of the building that affected that pylon and the view was the balcony of the western unit. That balcony used to extend straight off the western wall.
I remember that, yes.
Now we've pushed that balcony 2 metres east. We provided council with 3-dimensional view studies of those views from 42 Blues Point Road, and those views showed either a neutral or view gain, because we curved the corner of our living area, we curved the corner of the balcony, moved the balcony. Actually, I think it was 2.4 metres east. And what those view studies showed in that package, I wish I could share screen with you, but that's not possible in this scenario. But what I can wholeheartedly say is we proved to council that those views were maintained and in some cases improved.
Okay.
So you are right, the previous version of this design did have an effect on those views, but that was modified in October, November last year. And we gave council the evidence in the view loss diagrams.
Just my next question is about the condition proposing reducing the length of the balcony on level 3. And I think you've highlighted one of the issues that came to my mind about needing a cover over level 2 below. And I'm certainly not suggesting you put a pergola up, but I guess there are design solutions about a solid framed to provide some cover to that balcony below. I'm not suggesting that I'm inclined to go with that condition. I'm just thinking through the issues.
When I look at the architecture, I'm sorry if I sound passionate. It's probably partially that I am passionate about the design. It might even be my cultural heritage, whatever. But like, it's the Italian in me. That's why I can't talk unless I move my hands. But it's when I look at the solution, there is only one solution, and it's the continuation of that treatment around. It's been so well thought out, as you can see from the CGI. We're within the ADG controls. There's no overshadowing. There's no privacy issues because of that separation. But then if you are of mind to put that condition in about the planter box, it's addressed. So the ADG provides recommendations for private open space, minimums, but they also state where you don't have common areas and when you can and when it's applicable to provide more than the minimum. I mean, that part of level 3 is not even undercover. It's not even going to be used. It's more like a roof to the level 2 balcony. I see no gain whatsoever for 3 Woorong Street. I see severe detriment for the urban environment.
Thank you.
If that condition is imposed.
Thank you.
Pleasure.
Oh, another question. On level 3, there's a very small planter box adjoining the dining room. And as far as I can see, there's no way to maintain it.
Yeah, we'll probably have a safety. There's a few planter boxes around the building. There'll have to be anchor points and an access management plan on all of those planter boxes.
Okay, to maintain it from the outside.
Yeah, there's a few ways to do it. You can put some safety anchors on the roof. Landscapers abseil down. I mean, we've done similar things on high-rise buildings. So there's some companies like Bromic and other companies that provide safety rails. You put your harness on, you go down. Ultimately, these planters need to be managed by the owners corporation, not by the individuals, to ensure consistency. The other thing too is through plant selection, humidity moisturizers and irrigation, the maintenance of these planter boxes will be very low. Yeah.
Thank you.
They're not. No one needs to open a window and climb out on there.
That's what I'm hoping. Thank you.
Are there further, Meredith, do you have a question?
Yes, thanks, Chair. I had a couple of questions. Firstly, in relation, you talked about the contiguous piling wall, and I presume those are drilled piles and put in the Rio cages and pour them, and then excavate once the piles are in and the capping beams there.
Yep.
And I understand you're talking about that's to avoid any potential undermining and collapse from underneath the adjoining residence. I'm concerned about the issue of vibration. Have you put some thought into that? And
there's required to be there's vibration control measures on the boundary, and they should be able to, I mean, this will be in the detailed construction plan, but an alarm goes off when the vibration exceeds the requirements. So I'm pretty sure that's all in the geotech report, but that's another standard way of doing it. And the thing is, these days, that the drilling techniques and the drilling rigs are quite refined. These vibration control measures are almost standard on any excavation.
Standard, but not necessarily for a heritage item next door. So,
well, I mean, respectfully, yes. There's a lot of excavations next to heritage items, and in far more precarious positions than this, on far worse foundation material.
Okay, so you feel confident on that?
Yep.
Okay, and the other question I had, and it follows on from the questions that Greg had, in terms, you're clearly very passionate about the form of the building in terms of that level 3 balcony and the extent of that balcony, and what that does with the form of the building, and the concerns that have been raised are about privacy, and at the same time, your client wants to get views to the Opera House. I mean, one way, have you thought about potentially having a planter bed or the like that prevents people from going right to the edge of the balcony and looking down into the neighbours, but not requiring a high screen which would obscure views? Is that something you could consider?
Well, there's a condition about a planter box down the eastern side. That probably would address everything you're talking about, because then you couldn't go up to the balcony, edge of the balcony, and look down. It actually even requires a 2-metre planting, which I think is unnecessary, because if you can't go to the edge of the balcony and look down, then why do you need a 2-metre planting? That's going to block the views of the Harbour Bridge. So I don't think the condition is warranted because of non-compliance. Then if you are of mind to put the condition about the eastern planter box, then I don't think the 2-metre planting is warranted either, because you can't go close enough to the edge. I think there's a diagram in Mr. Vescio's report that shows the sight lines. We've got water gums as part of our landscaping treatment on the boundary. They've got a mature height between 6 and 12 metres generally. Then you're not going to be able to see through the water gums. Then even if you can see through the water gums, the angle of the view is so far that it's well beyond the 12 metres that the ADG talks about. But then if you are of mind to put the eastern planter box requirement, then you're not even going to be standing on the edge to look through the hedge that is meant to be 2 metres, that then looks through the water gums that are meant to be, like, there's so many barriers to the views. We're actually, I think, causing an issue for Unit 301 without any improvement for 3 Warong Street. So perhaps if you're of mind to want that eastern planter, then the 2-metre height's unnecessary.
Okay, thank you for that answer.
Pleasure.
And also going back to an item that Greg raised in terms of the maintenance of those external planter boxes, when you were describing abseiling off the side of the building to maintain them, and I'm sort of thinking of strata levies and the owners' corporation not wanting to do that, and we might end up with some, rather bedraggled plants. So I was concerned whether there might be an alternative.
I don't think in a building like this that will be a problem. It sounds scarier than it is. This job would be done in half a day. The companies that do this, like companies like Vertigo, cool name, but like the companies that do this, they just do it for a living. The guys are used to it. The fittest looking guys I've ever seen. it just gets done and it's over. When you're maintaining the extensive landscape areas, this will just form a very small part of the overall job, and the plant selection will be important because we're not going to be looking at plants that need very constant maintenance.
Thank you for that.
They'll probably design some drones with blades on them.
Yeah, maybe that's
too. So there's a good business
AI
idea.
clipping, AI landscaping. Good idea, Joe.
I've got some questions too, Rob.
Go for it. Sorry, apologies.
Okay, no, that's okay. I just want to start, Vince, just by clarifying something that you raised in your address to the panel, and that is that just to be clear, the panel deferred a decision on this matter last time. So those, and that was really to provide an opportunity for you to submit additional information and technical information, particularly in terms of geotechnical, but also to give you the opportunity to address some concerns around some of the design. That wasn't decisions in terms of which way the panel would decide. They weren't conditions. So it was not comprehensive because we didn't make a determination. So you raised something about, well, panel didn't list privacy, so we assume it was okay. I mean, I just wanted to be clear that we haven't made a decision. So so it was to give an opportunity for more information, not to list everything that was of concern. But then I've got a couple of questions. I guess might just start with the question of the balcony as well and the design, and this sort of builds a little bit on what Meredith was raising. Obviously, we have to balance all the different views in coming to a decision, and we've got an assessment report that's recommending one thing, and we have obviously submissions both from yourself, the applicant, and obviously neighbours. In terms of one of the things that I wondered about, obviously that eastern level 3 balcony was significantly sized. So I think it starts to go to one of the points that obviously comes up in design guides in terms of the size and the amount of use and that type of thing, and what impact that might have on the neighbouring property. But in terms of the proposed condition to do with screening, either with a fixed screen or a landscaping, are there any properties that you would be aware of? Obviously, there's not this view assessment undertaken at this stage in relation to the conditions that could potentially be impacted. And I'm thinking more properties that are higher up Blues Point Road that would have an angle down through there, that the privacy screen might obscure a view that hasn't yet been considered of the bridge. No,
there's not. We did all those view studies as well. And the views just really skim the edge of the roof. Not at all. There's no way that whether reasonable or unreasonable, a privacy screen on this balcony wouldn't affect those properties.
Okay. Yeah. And then I understand obviously the concern that you've raised about the draft suggested condition with the level 3, setting that back and then obviously that would take the roof of the balcony below. And I think maybe Meredith already inferred this in some ways, did you consider, or would it be appropriate if the usable area of the balcony of level 3 was brought back to the same line, so i.e. the balustrade was brought back to the same line as the western boundary, but you still retain, so in architectural expression and form, you're still retaining the I guess the slab or the roof form of the balcony below, but that became a roof garden, an inaccessible roof garden. So in other words, there's the size of the balcony for use is a good size, but it's smaller. It would stop more overlooking without having a screen at that front section, but it would, is there an architectural improvement that other than taking the slab that could still read as a good expression of the building without losing the integrity of the design in something like that?
Well, that's a much better suggestion. So absolutely, that's the thinking that I would be doing. I'm just staring at the image while I'm talking to you, just in case you're wondering why I'm not looking at the screen. I think that would work. However, and I know I'm being really fine in my detailing and use, I would leave the balustrade where it is and have that meter planter or inaccessible roof, because then that would wrap around the east side and then you definitely can't look. And not only, I know I said Owners Corporation doing planter boxes, but I think this planter box, which sounds like it might go on the southern side extending down the east, this planter box should be maintained by the actual occupant of the apartment. So then I'd prefer to leave the balustrade in its current position, which provides the barrier for doing the landscaping, and also still provides that symmetry, because then otherwise one of the forms would have a balustrade and the other wouldn't. And I know maybe I'm the only person that would have noticed that, but but I do go there sometimes. So yeah, but look, I think even from a safety perspective, what you're saying would further assist in the privacy. So then you're keeping people more than a metre off the edge of the balustrade. But I'd like to see something like that would work, I think, architecturally, but I wouldn't move the balustrade.
Okay. What other question did I have? Just a response to the 1 metre setback, the issue that was raised down. Sorry, I'll just scroll to the right plan. What plan is it? So it's the ground level plan. Obviously, we can see highlighted where you've set it in by the basement. That is an extra metre. Actually, it's probably the level below that.
Yeah.
The basement level plan. So obviously you come in from Henry Lawson Drive, and then there's quite a lot of space there before, driveway space that is, before you then get to the point where you go into obviously the shared car park area. Could you just explain the reason why you stopped the 1 metre setback at that point? Is it for passing, or I'm just trying to understand why?
It's the vehicle turning paths.
Right.
So the condition was required to further meter, but during the panel meeting, I think the discussion was about that area. Like, if you set the whole thing a metre, it would be a severely detrimental effect on the rock face, because that's like I said, that opening was designed very carefully in collaboration with council. And as to the fact that it goes straight, there is no heritage item near that part of the boundary. So I guess you could probably pivot it. Like, I'm just looking at the basement now, you could probably push the kink in 0.5 metre maximum, but the reason is the vehicular paths.
So to allow somebody to pull over if someone's entering or exiting that.
It's not even that. You have to turn to where the boundary steps in.
Yeah.
The B99 vehicle has to actually turn. And when a vehicle turns, the turning path is wider.
Right, okay.
And you can't just simply step it in immediately after the driveway, because the cars are going to scrape that corner. And Geotech's happy with that solution. The only thing I could say is that the southern piles could be made parallel to the boundary instead of in their current form, but that's probably an improvement of 300 mil. I don't think anyone's going to think that's of significant benefit, but could be done if necessary. Mm. The part that was in question really at the last panel meeting was the part that we moved, which is the bit that's adjacent to the heritage item.
Mm. Okay. The last matter I think that I just wanted to ask you about, and potentially this is actually a question that we'll ask the council officers. It's a drafting of conditions, but I know you've been mentioning a few different examples of where you've been dealing with the excavation on adjoining heritage items, and that's condition G18 that's in the draft report. And sorry, I will just scroll to it. So that's the condition damage to adjoining properties. And I know there's a double up in C and D. They say the same thing. So that just seems to be a typo that we can resolve. But if it was to be if it was to be approved. But in terms of subsection E, I don't know, do you have that condition up in front of you? Just for everyone's benefit, this is a condition, draft condition, damage to adjoining properties, requiring prior to the issue of an occupation certificate or report being prepared by appropriately qualified person being submitted to the private certified that does a few things. So certifies whether there's been any damage to adjoining properties has occurred, the nature and extent of any damage, the nature and extent of works required to rectify any damage caused. And then E is the nature and extent of any agreements entered into for rectification of any damage caused to the adjoining property. And as I said, it could be a question for council, but what I'm trying to understand is this is the conditions requiring a report on this to be submitted, just submitted to the private certifier that certifies these things that have been done. The M part of the condition talks about, all costs incurred in achieving compliance being borne by the developer. But I'm just wondering in relation to E, in terms of any agreements, how does that work in terms of actually placing, I guess, the onus on the developer to set timeframes and gain agreements with adjoining property owners to do any rectification work should any damage be caused?
I can give you a practical answer, but not a legal one.
Yeah.
Sorry.
No, I've been asked the question, so if I could answer it first, please.
Karen, was it directed at staff or was it directed to Mr. Squire?
No, directed. I don't understand. Sorry.
It was sorry.
I heard a double up.
Yeah, the question was understanding from Vince's perspective, given he's given examples of the similar thing on experience with heritage items, what they envisage or whether they've had any communication with their geotechnical engineer at the moment, because there are obviously recommendations in the geotechnical engineer's report on how he envisages that would work. And then, but then the technical drafting of the condition is more a question that will help for council.
So yeah, sorry about that. So from a practical perspective, once a dilapidation report has been provided, there's evidence of pre-existing conditions and pre-existing defects on that. Upon inspection of the protected items, if there has been further damage caused that were not in that dilapidation report, and if they are as a result of the construction, then yes, I've seen developers enter into agreements to rectify. I personally have never been involved in any major issue. The only ones I've ever really seen were like side footpaths and things close to the boundary. And in my experience, it's just been rectified expediently. So I haven't seen a major drawn out issue. And if there was one, then it's outside of my field of expertise.
That's okay. I think it's the drafting, the technical drafting, we can defer to council on that.
Yeah.
Thank you. That's all I had.
Thank you.
Any further questions from panelists?
Yeah, just a follow-up question. Sorry, back to Vince from me. I just need reminding. I remember the plans had the roof of the building in relation to the level 3 balcony doesn't align with the edge of the balcony. It's set back, I think.
Correct. Yes, it does.
So it's a floating roof that is set back from the line of the balcony.
Yeah.
Okay. And I think that's on the western balcony as well.
Yes.
It is slightly set back. Okay.
Yes.
All right.
Yeah.
Okay. Thank you.
That's also part of the architecture. So you get the concrete forms and then the roof floats and is set back. So it's been designed very carefully to provide that recessive setback top, which is another good reason why not altering. Another way of achieving the same result, as suggested by Cara, is probably a more appropriate way to do it than just to take to it with a blade.
Okay, thank you.
Are there any further questions then for the applicants? Okay, in which case I thank all members of the public for attending the meeting. We'll now go into a closed session to deliberate as a panel. So thank you very, very much. As indicated, anticipate that the determination will be published on the website before close of business today.
Thank you very much.
Thank you
Thanks
all.
all.
Bye-bye.
I think